Good afternoon, everyone. My name is Jennifer Aaron, and I thank you all for being here today. It is 12 noon. We have a presentation. We do have an error. The title we had was Guardianship Roadmap and Alternative Options. That is incorrect. The title of today's presentation is Alternative Destinations on the Road to Decision Making. That is the title and the information that will be provided for you today. Again, my name is Jennifer Aaron. I'm one of the parent consultants here at Parent Information Center. We have two amazing speakers today that will be addressing the topic. We have Marissa Bands, who is the project director of disability rights of Delaware Community Legal Aid Services, and also S. Hope Vella. She's the advocate for the disability rights of Delaware with Community Legal Aid Services. So without any further ado, I would like to turn it over to our speakers. Again, welcome these wonderful ladies with a wealth of information. Thank you for joining us.
Thank you so much, Jennifer, and welcome to everybody in the Zoom. As Jennifer said, Hope and I are both staff members with the Disability Rights Delaware program at Community Legal Aid Society. We were formerly known as Disabilities Law Program, but recently have changed our name. I am an attorney and Hope is an advocate, and we're very pleased to be here with you today. Okay. So hopefully everyone can see my PowerPoint presentation on the screen. Please holler if you cannot. Just some kind of introduction statements. Today's presentation is information that's meant to assist you and your family in making decisions about the future. It is not legal advice. Bear that in mind. It is general information for you to consider. We're going to be talking about decision-making options that are alternatives to guardianship. We are not going to be providing a presentation on guardianship. These are alternative decision-making options. It's important also to keep in mind, and as you'll hear throughout the presentation, that everybody has different needs. One of the things that we really suggest is thinking about what decisions need to be made and having that guide the decisions that you're making in terms of what decision-making supports are appropriate. We just want to note that we do assist with decision-making supports, many of the ones which we'll talk about today. We do not assist with obtaining guardianship over adults. Okay, so today we're going to talk generally first about what Community Legal Aid Society is, who Disability Rights Delaware is and what we do, and then we're going to go into the alternatives to guardianship. Okay, so Community Legal Aid Society Incorporated, or CLASI for short, is a not-for-profit law firm that's here in Delaware. We provide free civil legal services, so we don't handle criminal matters. We handle only civil matters. Our services are about equal access to justice. Our goal is to help Delawareans be independent and self-sufficient. We have a wide variety of services. So I'm going to talk in brief about our main programs here at CLASI. The first is our elder law program, which serves seniors over the age of 60. This program provides a broad range of services. Some of the common cases or types of issues that they help with include consumer problems, issues with manufactured homes and leases, landlord-tenant law, protections from abuse, decision-making supports like powers of attorney and advanced healthcare directives. We also have a medical legal partnership, which is a collaboration between specific healthcare providers and Community Legal Aid Society to provide legal services that are impacting problems that impact health. So we have partnerships with Christiana Care Health System, with the Division of Public Health, specific programs that support pregnant and newly parenting mothers. We have some partnerships with the YWCA and other domestic violence and sexual assault support agencies. We also have a partnership with Nemours Jessup Street, serving families whose children receive care at that clinic, as well as a partnership with the Division of Substance Abuse and Mental Health Services for certain beneficiaries of their services. We have a program in Kent and Sussex County supporting survivors of domestic violence with things like a protection from abuse order, custody matter, and other simple divorces and other matters. In Newcastle County, that program is not operated by us, it's operated by Delaware Volunteer Legal Services. We have an immigration program that provides immigration services to individuals who are victims of crime, domestic violence, or child abuse and neglect. We have a housing and fair housing program, which does eviction defense work, and also represents people who are victims of housing discrimination, so being treated differently based on a protected characteristic. Part of our fair housing program includes testing, kind of like secret shoppers, to verify that housing providers are not discriminating on the basis of a protected characteristic. We have a public benefits program that helps people with problems with services from the government, like Medicaid, TANF, SNAP or food stamps, and purchase of care, as well as Social Security benefits. We have a newly formed family representation unit, which will be representing parents who are in dependency and neglect proceedings. And finally, we have Disability Rights Delaware, which is the unit that Hope and I work in. So I'm going to go into a little bit more detail about Disability Rights Delaware. We are Delaware's governor-designated protection and advocacy system. There is a protection and advocacy system, or P&A for short, in every state and territory of the United States. We are Delaware's. We provide a really broad range of services to people with disabilities, from individual advocacy and representation to systemic advocacy and representation, things like class action lawsuits or class complaints. We provide information and referral services, as well as technical assistance to empower self-advocacy. We do community education, like today, self-advocacy training, and then we educate policymakers and serve on committees and councils that impact the lives of people with disabilities. So today, I'm going to turn things over to Hope to carry us on to the next topic.
Hi. So there are several decision-making options that we do here at CLASI. There are educational representatives, supported decision-making agreements, durable power of attorney, both broad and limited, advanced healthcare directives, healthcare surrogacy, guardianship of person and of property. The first thing that we look at when we have a client come in is capacity. Our law assumes that every adult that's 18 and over has capacity. That means the ability to make decisions. One size does not fit all. There's a spectrum of legal and informal constructs available to assist individuals who may need help making decisions. We here at CLASI do everything that we can to provide people with intellectual and developmental disabilities with every opportunity possible to express their needs and to comprehend the actions that we're trying to take. Capacity is specific to the decision that needs to be made. Bad decisions. Adults, whether they have disabilities or not, have the right to make bad decisions. Mistakes are part of a learning and growing process. And back to Marissa.
So I always like to, this is something that's really hard for, I think, any parent to go through the process of their child transitioning into adulthood. So one thing I will encourage is that you think about are the decisions that I'm worried about, are they because my child is young and inexperienced, or are they because of disability? And really think about that. Is there a disability-based reason why you are concerned about your child's ability to make decisions? Or is it the very understandable and common just concern about children aging into adulthood?
I also think about children that don't have disabilities. We still steward them and we try to help them make the wisest decision, but they're going to take risks, and there's dignity in risk taking.
Okay. So now we're going to turn to specific decision-making supports that are available to support a child with a disability who's become an adult. So first, we're going to talk about education decision-makings. If your child has an IEP, you have likely been having to fight for them every IEP meeting and in between, trying to make sure that the school does right by them, to give them the services that they need for a free and appropriate public education. A lot of parents are really concerned that when a child turns 18, and if they're still in school receiving special education services, that the school is going to pull the wool over their child's eyes and take advantage of their youth and lack of experience with advocating in special education contexts. So there are ways to address this. Under the Federal Individuals with Disabilities Education Act, states are required to have a process by which the transition of decision-making authority is either transitioned to the student or someone else, or remains with the person that was serving as the parent for educational purposes, whether they're the biological adoptive parent or some other individual that fits the legal definition of parent under the federal IDEA. So the default assumption, like in other areas in education, is that when a student turns 18, they make their own decisions. In order to meet the requirements of IDEA, Delaware has created a process by statute and regulation by which an IEP team evaluates ahead of a student turning 18 whether or not the student will have capacity at age 18 to make his or her own decisions about their education. So this has to be an IEP team meeting that's done. The parent and the child both have to be invited. If there's a question about capacity, there's some other people that have to be invited, including a school psychologist that's familiar with the student. So at this meeting, the IEP team has to follow a specific process with questions to establish whether or not the student has education-specific decision-making capacity. And you'll hear us talking about specific capacity because there is no single definition of capacity. It is always specific to the decision that is being made. So your capacity to make educational decisions is not going to necessarily be the same as your capacity to make medical decisions or your capacity to make financial decisions. You may have capacity for some decisions, but not others. So it's always important to think about the context of the decision. What does one need to understand in terms of risks and benefits of a course of action and consequences of a course of action? So at this meeting, where the IEP team and potentially the school psychologist, if needed to resolve capacity, they will make a decision whether or not your student has capacity. If it's if there's a conflict within the team about whether or not, then it's going to be resolved in the favor of the student. That will be the default. There are appeal processes that both the student and the parent can exercise to contest a decision about decision-making capacity. So what happens once the IEP team makes a capacity decision? If the student is found to lack capacity, the IEP team will select an educational representative. The first priority is always a willing and available parent. Again, using parent in the context of the legal definition under IDEA, which can include adoptive or biological parents. It could include a caretaker that was making educational decisions under our caretaking law in Delaware. It could be an educational surrogate parent. If the student is determined to have capacity, then the student has two choices at that point. They can choose to exercise his or her own authority, or they could choose to voluntarily grant somebody else the ability to make educational decisions for them. So this is like a power of attorney, which we'll be talking about later, but specifically for education. So this is really helpful for situations where the student has capacity to make educational decisions, but maybe is prone to undue influence. And the student wants, mom, dad, grandma, whoever was, is their support person, to be able to communicate with the school and communicate educational decisions. So that voluntary grant of authority is available to help in those situations. I will also add that if the student who's over 18 already has legal guardianship established through the Court of Chancery, then this process would be bypassed. Or if the student has already done a power of attorney giving a parent or other individual the ability to make decision making, then this process again can be bypassed. All right, I'm going to turn it back to you, Hope. Oh, no, that's my slide. Apologies. So what is advanced decision-making planning? So advanced decision-making planning is making decisions about medical care, where you live, what kind of education, employment you want, finances, and daily activities. So pretty broad range of decision making, and there are different mechanisms that you can use to help plan ahead of time, what your wishes are, who you want to support you. So Hope is gonna pick up and talk about the first option.
Thanks, Marissa. The first option is supported decision-making, and we're going to go from the least restrictive to the most restrictive. Supported decision-making helps the person with a disability receive support in making their own decisions. It considers that an individual with disability has the capacity to make decisions even when they have an intellectual or developmental disability. They respect the rights and the ability of adults with disabilities to choose who supports them. Nobody is appointed. This person is selected by the individual themselves. We respect the right of a person with a disability to choose which areas of their lives that they'll allow others to participate in the decision-making process. We respect the rights of adults with disabilities to have the dignity of having opportunities to take risks, make mistakes, and correct and learn from the mistakes like other adults. And it empowers an individual with a disability to revoke privileges at any time.
And just before we move on, one of the kind of to look at the big picture, bird's eye kind of view, supported decision making is about giving support to someone who is making their own decisions. So no decision making power is transferred to the supporters. Instead, you are there. I'm just going to move back to that first image. You are there to support them in making decisions. So that can include helping them with getting information, talking, for example, with the doctor about the risks and benefits of a procedure, explaining it to the individual who's making the decision in a way that's understandable to them. It can be communicating for them. So maybe they have alternative means of communication and aren't able to verbally or sign with the doctor about what a decision is. So supported decision making can also provide support in that way. And it covers more than medical decision making. I'm just using that as an example.
The neatest thing about supported decision making is the supporter brings all the information to the individual with the disability, and the final decision making is always in the hands of the person with the disability. Thank you.
Ready?
I am, I'm sorry. The next is the durable power of attorney. It allows a person, a competent adult, to choose an agent to speak for them and to make decisions in designated domains of a person with a disability's financial life. It's dynamic. It's according to an individual's level of function at a point in time. That means that the person with the disability is able to make their own decisions at a point that if they come to a point where they cannot speak for themselves, at that point in time, the person that is their agent can speak. It's financially driven. It places responsibility on the agent to act in the best interest of the person with the disability, closest to what you would know that person's wishes would be. And it also empowers a person with a disability to revoke those privileges at any time. This would be speaking to the insurance companies, speaking to medical staff, having access to their medical records, making decisions even. Oh, I'm sorry. I'm on the next one. Going to their banks, having access to their bank account, having access to electronically to their banking information. If there's if they have a trust, you would be able to have access to the information in their trust. You helping them pay their bills. Anything that is in the financial domain in the person's daily living.
Thanks, Hope. And it's important to note that there are specific requirements in Delaware about what the document contains, and what how it's executed, meaning who witnesses it, who prepares it. So we do recommend that attorneys, that you work with an attorney for a durable power of attorney. Supported decision making you can work with an attorney for, or there's actually a form on the Department of Health and Social Services website that you can use to create a supported decision making agreement. So that's also just one difference with the durable power of attorney. Another thing to note is that powers of attorney can either be what we call springing or non-springing, and that's a legal term, which basically means it either goes into effect now or it goes into effect when the person with the disability has lost their capacity to make the decisions that are covered by the power of attorney. So that's a personal choice on whether someone wants their agent, which is the term for the person who is given power under the power of attorney, whether they want their agent to act now or only if like something happens to them, like they're hospitalized in a coma, as an example. With the powers of attorney that are effective immediately, what happens is that both the individual with the disability and the agent have the ability to make the decisions that are covered by the power of attorney. So for example, either one could go to the bank and withdraw money, versus the supported decision-making agreement where only the individual with the disability has the power to make the ultimate decision. So those are just kind of important details to remember in terms of what option is the best for your family. And sometimes we find that people go with multiple options. So they might have a supported decision-making agreement for decisions now, but use a power of attorney for if something really bad happens and they can't make their own decisions.
The Advanced Healthcare Directive. This is one, especially if our children are young or our loved one is young, we don't think about, but we always need to plan for those instances in which they can't communicate for themselves and they can't make decisions for themselves, as we should do for ourselves also. It allows the adult to record their end-of-life treatment wishes. It allows the adult to choose an agent to make healthcare decisions when they no longer have the capacity to do so. It allows the adult to leave special instructions for their agents, like organ donation and other end-of-life decisions. It empowers an individual with a disability to revoke privileges at any time, as long as they have capacity. This covers things like if a person with a disability has been told that they have something and they're not going to survive from it. What are their wishes? Do they want life-saving procedures to be given? Are they going to want pain medications? Do they want to be an organ donor? Do they want their agent, in the cases that they are unable to make decisions for themselves, do they want their agent to make all of those decisions? They have the opportunity to be as specific to their wishes as they would like, or in most areas have their agent make those decisions for them. I'd like to go back a little bit, because one thing about these documents is for someone that has an intellectual disability or a developmental disability, anything that impacts them cognitively, this language could be difficult to understand. And when I spoke earlier about us doing everything that we can to ensure that the person understands, ensure that the person is able to communicate their wishes, We use plain language to explain the information. When the person is allowed to communicate with us verbally, or by using buttons on a tablet that say yes, no, I don't understand. Physical buttons that they can communicate yes, no, I don't know, I don't understand. They can also use, we also use a picture support system. So for instance, to explain somebody purchasing stocks for a company, we would use find out what the person's favorite thing is. If it was animals, they would have a pet store, and they don't have enough money for that pet store. So we're going to have people that invest. So everybody that's in the room gets a physical card with money in it, and they invest, they put it in the store, and we use it to explain how the person gets money back when they pull out, etc. So they have pictures that they can point to communicate. There's pictures that represent their family members. If someone needs sign language interpreting, there will be an interpreter present. We will do whatever it takes to communicate in a way that that person best communicates.
And that's actually a good segue to, there was a bill passed last year in Delaware that modifies the Delaware Advanced Healthcare Directives and health surrogacy, which we'll talk about next. So there will be some changes coming. That law goes into effect in the fall. One of the changes is that it makes it clear that when determining if somebody has capacity to make decisions, that that you have to consider if they have capacity when using reasonable accommodations, like support people to help explain, communication devices to facilitate communication, and all of those other ways that we use to ensure communication and comprehension of people with disabilities. So that will be explicitly required in the law once that change goes into effect in September. Also, there will be a new legal document called an Advanced Psychiatric Directive for individuals with psychiatric disabilities to communicate what their wishes are in terms of psychiatric treatment should they decompensate to a point where they cannot make their own decisions. So stay tuned on that. We will be releasing guidance and information about those changes as we get closer to the fall. Okay. Now we're going to talk about healthcare surrogacy. And again, with the caveat that this is changing a bit in the fall. The general concept is going to be about the same, but some of the details will be different. But what healthcare surrogacy is that when there's no advanced planning document, and someone does not have the ability to make their own medical decisions, there's a way for the physician that's treating them to designate somebody else as a surrogate decision maker. So standing in the person's shoes to make the medical decision making. This is a really, really important law because it ensures that people who don't have capacity to make medical decisions can still get medical care and have someone consent for their medical care, provided that they have a health surrogate available. So this health surrogacy has a order of priorities of relationships to the individual receiving the medical care. So, for example, parents, spouse, adult children, adult nieces, and it's in a specific order. So the physician would first turn to the highest priority individual to designate them as a surrogate. This is something that's really easy to do in collaboration with your physician. They can record it in a note or a letter, and then you can take that and present it to, you know, the managed care organization, the hospital, wherever the individual with the disability is receiving care, so that you can make those decisions on their behalf. There's no legal process that's required to make this healthcare surrogate designation. So it is really helpful for medical decision making that needs to be made when someone does not have the ability to make their own decisions.
Marissa, would this have been helpful back when COVID was when we were in our lockdown?
So this law has been in effect for many years. It was applicable in COVID and certainly was used during COVID. We did have people who were becoming suddenly and catastrophically ill who didn't have advanced planning documents. So the medical community would have to look to and designate a healthcare surrogate to make those medical decisions. For example, while someone was in a coma or intubated and couldn't communicate. And again, this law is changing, it's adding some more procedures, for example, how to contest surrogacy or capacity determination. So we will be releasing information in the fall about the new procedures. Okay. Lastly, we have on the menu of options, and we've presented these options roughly in the spectrum of least invasive to most invasive. So guardianship. Guardianship is a court process. You cannot have guardianship of someone over 18 without having a court order. So even if you had a guardianship order for someone when they were a child, guardianship over an adult is a different process. In Delaware, we have two different forms of guardianship: guardianship of the person, guardianship of the property. Guardianship of the person is like decisions that a parent would make for a child, where they live, where they go to the doctor, that sort of thing, whereas guardianship of property is financial decision making. What's really important to understand about guardianship is that it removes the ability for a person with a disability to make their own decisions. So unlike the other options, which give somebody else either power to support or power to make decisions in addition to the person with the disability, or only instead if the person loses capacity, this is taking those decisions and giving them to somebody else. Guardianship proceedings can be lengthy. They can be contested, meaning, you know, somebody disagrees with it. So it may involve a trial. The person who's subject to the guardianship proceedings has certain rights during the proceedings to make sure that their voice is heard during the guardianship proceeding. In Delaware, guardianships can be limited to certain decisions, or it can be a broad kind of sweeping power to make decisions on behalf of a person with a disability. The guardianship in Delaware is frequently used. We're looking more and learning more about alternative ways to communicate, to establish capacity, and alternatives to guardianship, which is something that may become part of the guardianship process in the future, in terms of looking kind of like with an IEP, did we try less restrictive alternatives first? All right. So Hope, you want to take us from here?
Sure. So CLASI has offices in all 3 counties in Delaware, and here are the numbers that you can contact us. This would be the number for you to do the intake with our reception, and they would be able to direct the referral to the correct department. Are there any questions?
I believe, ladies and gentlemen, that the presentation is over from our wonderful speakers that provided wealth of information. Just it's amazing. So we're definitely opening it up for questions. And I do see a raised hand for from Kate Rizolova. I apologize if I
Yes.
input correctly, Kate, from DSAAPD. You have a question?
Yes, thank you so much for presentation. I just wanted to get some clarification. Um, is it accurate to say that the guardians can be caregivers or not?
So can you clarify if you mean caregiver, like a family member caring for someone, or a paid caregiver?
Either one, either one. Just the family, because right now the national strategy considers caregivers as a paid and unpaid. So it's expanded the definition of caregivers. So it could be your neighbors that could come and stay with your loved one, and they get paid, and and be also considered as a caregiver. While Mary is the mother of the Billy, could go take care of her business and have her neighbor taking care of Billy.
So certainly frequently we see family caregivers serving as guardian. A paid caregiver, I think, is a more complicated question. There's paid caregivers that are through agencies, which there's potentials for conflict of interest. I think that some agencies would not allow their staff to serve that role. There are fee-for-service guardians who are paid to provide guardianship service, but that's a different service than caregiving. And then there's a different question as to qualifications for serving as a paid caregiver under a Medicaid program, for example, self-directed attendant care. Which I don't have the answer off the top of my head on how that would intersect, but we do see family members who are caregivers serving as guardians, or as other agents or supporters in an alternative to guardianship.
Thank you.
Do we have any other questions or comments from anyone?
Thank you for having these kind of seminars. They're very useful. Do we get a copy of the slides?
That's fine with us. We can send a PDF copy to PIG if they're able to distribute it to the attendees. I will also add, for guardianship, there are some specific exclusions about the powers of what a guardian has to get court approval to do. So for any decision making, we really encourage you to consult with an attorney about what's the best option for your family and what's least restrictive, and making sure that your decision making is being guided by what decisions actually need to be made.
If I may ask, Marissa, is it, I know this was more geared for open decision-making, more so than guardianship. How in-depth, and I think you touched on it, but how in-depth is it, or how complex is it for guardianship once you made decision for guardianship to come out of guardianship, opposed to decision making, you know, capacity.
It's slow, complex, can be emotionally painful to go through guardianship. A lot of times people have difficulty navigating it without an attorney because it is a complex court proceeding. The individual with disability has significant rights, as they should, before their rights are taken away. That things that have to be followed, individuals who have to be notified of the guardianship proceedings. So it's not a quick option. It is not a cheap option, and it can cause significant family conflict, not just with the person with the disability, but also with other family members who don't agree about whether or not a guardianship is appropriate. Versus the other decision-making supports, if the person has capacity, many of them can be done without an attorney. Those that do need an attorney, like a power of attorney, is really best done by an attorney. There are some free options for those services, including our program. We provide decision-making alternatives like powers of attorney, supported decision-making, and advanced healthcare directives free of cost, as does, to some extent, the Delaware Volunteer Legal Services. So that is a less painful process in terms of how quickly you can get it done, affordability, and then, of course, most at the forefront for us is that we always want to go least restrictive in terms of a person with a disability and empower them to be able to make their own decisions as much as possible.
Thank you. And I do have one more other question as well. Lady Marissa or Hope. Is there a timeline? Like, so if a child is going to turn 18 in March, the IEP meeting takes place, they would try to have it maybe in February. Is there a time frame that they would want to make this decision before 18, or can they go one day after 18, or no?
So,
And because there's some kids that are staying in school till they're 22, so how also does that affect anything with them being in school that long? If that makes sense.
So yes, so educational decision making should be the discussion with the IEP team should begin a year before the child turns 18. So at the IEP meeting in which they're 17, and then the decision is reviewed annually. So capacity can change over time. I'm going to give you an example of someone with a brain injury who is going through some rehabilitation, some cognitive services to recover from the brain injury. And as time passes and they get further from the injury, they become able to make their own decisions. So maybe at the first point in time, when they were 18, they did not have capacity, but then a year later at 19, they do. So that's a decision that should be reviewed annually by the IEP team. For other decision-making options, supported decision-making, advanced healthcare directives, and powers of attorney, they cannot be executed, meaning signed by the necessary parties until someone is 18, but you can begin the conversations before 18 to establish what is appropriate and what the person with the disability wants.
I also encourage people when they start the transition discussions to start thinking about what are the next steps, because transition is looking at how the student is going to live after after they turn 18. So to start thinking about it, so we're not rushing at 17, to try to figure out what they're going to do, or right when they're getting ready to turn 18 and feeling like, what are you going to do? You're not allowed in your child's portal anymore for the hospital. They won't give you information. So start thinking about it. And so when you get to that magic age of 18, you already have a plan in place and you know where you're going to go. And the client or the individual with the disability knows what they want to do and who they want to help them do it.
Thank you, Hope. Do we have any other questions at this time? I see Natalie Minus. Go ahead.
Hi, yes. I wanted to ask, so say for example, if a child is approaching 18 and needs to be under a guardianship, but like financially it's not feasible at the moment, is there anything that could be put in place so the parent is not completely shut out?
So the options, if a child does not have capacity to make decisions with supports and accommodations, there's healthcare surrogacy, which provides the surrogate the ability to make medical decision making. That is not a court process. That is something that's done with the treating doctor. And then there's educational decision making, which is where the IEP team will determine if the child has capacity to make educational decisions. And if not, then they'll appoint an educational representative, which is the default is the person that served as the parent in the IEP while they were under 18. The other options, advanced healthcare directives and power of attorney and supported decision making, are only available for people that have the capacity to understand what the documents in plain language mean. So like Hope talked about, we have a lot of strategies that we use at our office to put the legal information into plain language and to use alternative means of communication. So we're always happy to explore with the person and their family about whether, using those other means, if we're able to establish capacity to do an alternative to guardianship. So anyone who's interested in pursuing that for their family members, welcome to, I'll just move back a slide. We have offices in all 3 counties. You just would have help the person to contact our office to do an intake. If they're not able to communicate on the phone, then you can do it for them.
Okay, thank you.
But just again, we do not do guardianship, so it is only the alternatives.
Okay. And that was my other question too, Marissa, is there attorneys in your offices statewide that would do guardianship, and you're telling, if I'm understanding you correctly, no?
No, we do not do guardianship.
Okay, thank you. Any further questions? This has been a great conversation and information that has been provided from Marissa and Hope. If there's no further questions, we do ask that you please take a moment to complete the survey. That's right in front of you. And we thank you, Marissa and Hope, for taking the time out to educate us. At some point, all of us may have that opportunity to, either look at decision making or whether, another option of guardianship. But we thank you for providing that information. And if we have any questions, we know where to find you all.
You have a hand up, Esther.
Let's see, I don't see it.
It was Esther Olatunji, and she, go ahead, Esther.
Oh, no, I just was clapping for you guys. Was just to say
Okay.
thank you.
Oh, thank you so much. And I just encourage, if you're not sure what's right, you know, you're welcome to call us, and we can do an intake, talk to your child and about the options. And it's no commitment. We're free. So we are here as a resource if you're just trying to learn more about the options that are available, and there's no commitment to us.
Well, again, I want to thank everyone for joining us this afternoon, and continue to have an amazing day. Stay warm. Be careful out there if you're on the roads, and enjoy the rest of your week. Thank you, ladies.
Thank you, everybody.
Thank you.
Bye-bye.